local special needs planning attorney with the Walser Law Firm. And during today's webinar, we're going to discuss preparing for your loved one's future. And we're going to review some vital tools for special needs planning, Medicaid planning, and guardianship. Before I really start and go over the topics of today's webinar, I'll give you a little background information about myself. I'm originally from Georgia. I moved to Florida over 10 years ago for law school. I have a younger brother with Down syndrome that's greatly influenced my career and my specialty of special needs planning. So I've always been very involved with organizations and families with special needs individuals to help educate them, and have seen everything firsthand. I've been practicing law for over 8 years in Palm Beach County, and I've had the pleasure of volunteering with the Els for Autism Foundation for over 7 years. Now, to get into our presentation for today, before I jump into the specifics about special needs planning, I want to briefly review what estate planning is and why it's so important. Estate planning is the process by which a person designs a strategy and prepares documents to conserve, protect, and distribute their assets upon their passing for the benefit of a loved one and charities. So most clients have a question of, why do I need an estate plan? Why is it so important? Estate planning is important because it helps plan for your life, longevity, and legacy. It helps protect yourself and your family from unnecessary stresses arising from probate. And most importantly, it protects the inheritance that you want to leave to your loved ones with special needs. Now, what happens if I don't have an estate plan and I pass away without a last will? In essence, the state of Florida decides where your assets go. That's called the rules of intestacy. The reason why we want to avoid that and why we're talking about special needs planning today is because under Florida's rules of intestacy, your assets would go outright to your loved ones. And if one of your loved ones has special needs, that outright inheritance may render them ineligible for government benefits. That is the main goal that we want to avoid today. We do not want to render our loved ones ineligible for government benefits. We want to protect and preserve those assets for that special needs individual. So like I was just saying, your generous inheritance or gift could render your loved one ineligible for government benefits that he or she would otherwise be entitled to, like Social Security or Medicaid. Prior to the use of special needs trusts that we're going to talk about today, which is a fantastic tool, a lot of families used disinheritance. In essence, what disinheritance is a parent would leave inheritance to a non-disabled sibling or family member to hold the assets for the benefit of the disabled sibling or family member. This created a lot of issues. First, there was no guarantee that the non-disabled family member was going to use the assets for our special needs loved one. Secondly, it opened up the assets to possible liabilities, such as judgments from car accidents, bankruptcy, or divorces that potentially the non-disabled family member was going through. So using a special needs trust is a much more effective tool because it guarantees that the funds will be held only for the benefit of the special needs individual and not for any other purpose. And most importantly, it'll protect those assets for government benefit eligibility. Generally speaking, a special needs trust, also known as a supplemental needs trust, or you will also see me refer to it throughout today's presentation as an S&T. It's one of the best options for planning and providing for your loved ones with disabilities. A special needs trust is designed so the trustee can provide life-enhancing services that the government does not ordinarily cover. Some of these services may include special wheelchairs or other equipment, therapies, travel expenses, recreational expenses, extra personal nursing care, extra services, or expenses required to maintain his or her standard of living, and the list goes on as to what a special needs trust can provide. The assets in the trust are not available to the beneficiary for the asking, but they're totally discretionary and under the trustee's control. Therefore, the assets are excluded by the government when it evaluates your loved one's eligibility for benefits, which is the main goal in today's discussion. There are two types of special needs trusts: a first party or self-settled special needs trust, and a third party special needs trust. The third party special needs trust is the trust that we're really going to focus our discussion on today, because that is the best vehicle for providing inheritance and gifts to your loved ones with special needs. But I want to briefly touch on a first party special needs trust, since a lot of individuals have heard of it, and it's important to know the differences between the two and why a third-party trust is better suited for your inheritance than a first-party trust. A first-party trust, it's also referred to as a D4A trust. A lot of people have heard it that way. Basically, that just alludes to where they can find the law in the federal statute that authorizes these types of trust. In order to establish a first-party trust, a couple things have to be met. First, the trust must be irrevocable, and it must be established for the sole benefit of the trust beneficiary. The trust has to be established by the beneficiary's parent, grandparent, legal guardian, or the court. Luckily, the law was recently amended and expanded to now allow the disabled individual themselves to establish a first-party trust, which was a huge leap forward. And lastly, the beneficiary must be under the age of 65, and the assets in the trust must belong to the beneficiary. The major downfall with a first-party supplemental needs trust, outside of the fact that it's irrevocable and so forth, is that a first-party supplemental needs trust has a Medicaid payback provision. So what that means is, upon the passing of the trust beneficiary, any remaining funds in the trust must be used to reimburse the state for medical benefits provided over the disabled individual's lifetime. This is something we definitely want to avoid. No one wants to have a Medicaid payback provision in your trust. Typically, the only time you would ever need a first-party trust is if a disabled individual was receiving some sort of settlement from potentially a car accident or some other type of negligence case. In that situation, the assets are the beneficiary's assets. And if the beneficiary is receiving government benefits, a first-party special needs trust would be most appropriate to protect those settlement proceeds so that beneficiary does not lose their government benefits. The only other time you would typically see a first-party special needs trust used is if a family member did not effectively plan to leave inheritance to a disabled loved one. Like I had mentioned earlier, if they did not have an estate plan at all and the assets went to the disabled individual outright. In that situation, the court would set up a first-party special needs trust to protect that inheritance that was originally left outright. That way, the disabled individual does not lose their government benefits. But again, the entire goal would be to avoid setting up a first-party trust and the Medicaid payback provision by effectively planning ahead of time and creating a third-party special needs trust. A third-party special needs trust is funded with assets belonging to a person other than the beneficiary. In fact, no funds belonging to the beneficiary may be used to fund the trust. This is the type of trust that is funded typically with gifts, inheritance from parents, grandparents, other family members, and proceeds from life insurance policies. Unlike the first-party special needs trust that we just went over, a third-party special needs trust does not have a Medicaid payback provision. This is a huge, huge win, and this is why we want to use third-party special needs trusts to leave inheritance to our disabled loved ones. Because what this does is it allows the person that's creating the trust to decide how the trust assets are distributed when that beneficiary passes away. The person creating the trust then gets the option to say that they want the remaining trust assets to be distributed to other family members, to other friends, to other loved ones, or charities such as the Els for Autism Foundation. It gives you much more flexibility. In addition, a third-party special needs trust can be revocable during the trust creator's lifetime. So you have the ability to change, amend, and mold this trust during your life so it best meets your needs and goals upon your passing. A third-party special needs trust, just like a first party, also protects the assets in the trust for the beneficiary's government benefits. The way it does that is the beneficiary of a third-party special needs trust does not have the legal authority to revoke or terminate the trust or to direct the use of the trust assets for his or her own support and maintenance. That is why the assets are not countable assets for government benefit purposes. Now, just to summarize the two main differences between a first party and a third party special needs trust, and to highlight why a third party special needs trust is the type of trust you would want to use in order to leave inheritance to a loved one or family member who may have a disability and who may be eligible to receive government benefits. The first major difference is whose assets are being used to fund the trust. If it is your assets that you are leaving to a loved one, either through inheritance or if you want to give them a gift, a third-party special needs trust is the trust you want to use. Like I had mentioned in the previous slides, it's revocable, it's customizable, and most importantly, there is no Medicaid payback provision. Therefore, the trust creator gets to say where the trust assets go upon the passing of the disabled beneficiary. they get to say that it goes to other family members, loved ones, charities, whoever they like. Whereas with a first party special needs trust, there is a Medicaid payback provision. The trust is irrevocable, so you cannot change it. It is not customizable. And the grantor or the trust creator, they cannot direct that the trust assets go to other family members or charities or friends or loved ones. Now that we've talked about the different types of special needs trust, we're going to briefly discuss how we can fund these trusts, as a trust is only as effective as its funding. So this is where you would need to sit down and make a thorough list of your assets. Write out each asset in detail. List the value of each asset, the ownership structure, who your desired recipients of the asset is at your passing. Why this is important is because you have a choice with a third-party special needs trust. You can choose to fund that trust now while you're living with a gift, or you can earmark certain funds through other estate planning documents or pay on death designations or accounts to state that those assets will flow directly into that third-party special needs trust upon your passing. Now I'm going to briefly turn over the presentation to my good friend and colleague, Julia Lembcke. Julia is a financial advisor and co-owner of URS Advisory and URS Insurance. She's going to briefly review some of the details regarding trust funding, life insurance, and a special type of life insurance policy that can provide charitable donations.
Thank you so much, Christa. Now that we're all more versed on how special needs trusts work, I'm just going to take a couple of minutes to explain why life insurance might just be the ideal tool for funding your special needs trust. Like Christa said, I'm Julia Lembcke, certified financial planner and co-owner of URS Advisory. We're a comprehensive retirement planning firm with offices in Stewart and West Palm Beach. So I'm going to go ahead and share my screen with you and get going. Okay. All right, can everyone see this?
Yes.
Okay, great. All right. So first, before we get into why life insurance might be ideal for your special needs trust, let's review the different types of life insurance that can potentially fund the trust. Life insurance is a contract between a policyholder and an insurance company, where the insurance company guarantees payment of a death benefit to named beneficiaries upon the insured's death in exchange for premiums paid by the policyholder. For instance, I pay $85 a month to insure my life for $1 million for the next 25 years. Therefore, if I die in the next 25 years, as long as I've paid my $85 monthly premium, my beneficiaries will receive $1 million income tax-free upon my death. This is an example of term life insurance. I am insuring my life for a finite period of time for a low price in return for a large lump sum upon my death. There are also different forms of whole life insurance. In other words, insurance that pays out no matter how long you live. These can be in the form of guaranteed universal life, indexed universal life, variable life, or whole life. It is important to note that whole life policies are complex and need to be fully explained and understood before you invest. The type of whole life insurance policy you choose will be based on your preferences. The point is to have a policy that will take care of your loved one with special needs regardless of when you pass away. So why is a life insurance policy the ideal funding mechanism for your special needs trust? As you all know, the task of funding a special needs trust with enough money to pay for your loved one's care can be a very daunting task. If you or your spouse weren't here, how would your child's guardian easily access the funds to provide living accommodations, a care manager, and their medical and custodial care? You probably have retirement accounts, brokerage accounts, and other savings in your estate with which to provide the funds. But are those accounts primed to handle the ongoing needs of your loved one? What happens when you have other children that you'd like to leave a legacy to? And what about income tax implications? Making sure that you have enough in your estate to cover your special needs loved ones plus other family members can be very difficult without a life insurance policy. Your ability to accommodate your child is likely based on your current employment plus your savings. If you pass away, will your savings be enough to cover the ongoing needs of your loved one? What if you need to leave significantly more to your special needs child than you do your other children? If you're planning to fund your special needs trust with traditional retirement accounts, i.e. 401ks or IRAs, please be aware that federal income tax will be due on the account balance at the trust beneficiary's tax rate, which means that not all of your account balance can be used to provide for your child. Life insurance is the ideal tool for taking care of your special needs child for three main reasons. The first is the low cost of the policy relative to the death benefit. Secondly, the funds are immediately available upon death. And third, life insurance death benefits are paid out income tax-free. Take the Johnson family. Ted and Beverly Johnson are in their early 50s and have 3 children, David, Mary, and Ben. Ben was diagnosed with autism at age 7 and has needed a lot of time, effort, and love throughout his life. Beverly was able to stop working to stay at home to provide and facilitate Ben's care as Ted earns a great living. Ben receives behavior therapy, speech language therapy, and nutritional therapy on a regular basis, as well as full-time custodial care from Beverly. Upon their death, they need to be able to ensure that Ben will receive the same great care that he's used to, and if possible, they'd like to leave a legacy for their other children. Here is a picture of their assets. They've got $150,000 in a savings account, $700,000 in Ted's 401k, $450,000 in Beverly's IRA, $300,000 in a joint brokerage, and a $750,000 home with a $400,000 mortgage. To maintain Beverly and Ben's quality of life in the absence of Ted would require every penny of these assets. Although this may seem like a lot, if Ted dies anytime soon, his family will be missing out on 10 to 20 working years of his income that is vital to provide for Beverly and for Ben's care. If both Ted and Beverly die, not only will they have to provide for Ben's care, but for a new caretaker as well. Instead of worrying about saving more and spending less in the hopes that they could amass the sum necessary to maintain their lifestyles and care for Ben, the Johnsons purchased a second-to-die whole life policy that will fund Ben's special needs trust upon the death of both Ted and Beverly. This way, they can ensure that there will be enough assets to provide for Ben's care, even if one or both of them lives a long life. Their second-to-die policy is a guaranteed universal life policy, which means that their premiums are fixed for life. They will be paying $12,000 a year or $1,000 a month for a $1 million second-to-die whole life policy. This gives them peace of mind knowing that they can use their other assets to maintain their lifestyle and provide for themselves while ensuring that Ben gets everything he needs to thrive. If they die unexpectedly together, Ben's trust will receive $1 million income tax-free within days of their passing. If one or both of them live into their 90s, they will have paid roughly $500,000 into a policy that will pay out a guaranteed $1 million income tax-free. That's a pretty good return on investment. Essentially, you're paying pennies on the dollar to ensure that your special needs child will receive everything they need to thrive in your absence. If you happen to be charitably inclined, there are a few insurance companies that are offering what's called a charitable benefit rider. This rider will provide an extra 1% of your death benefit to a 501c organization of your choice. For the Johnsons, the AANE is their charity of choice. So upon their death, Ben's Special Needs Trust will receive the full $1 million, and AANE will receive $10,000 on behalf of the Johnsons. This feature is included in the cost of your policy. In summary, purchasing a life insurance policy to fund your special needs trust offers a relatively inexpensive and income tax friendly way to protect your child as well as provide for the rest of your family. If you are curious about how a life insurance policy may make funding your special needs trust a lot easier, please feel free to reach out to me by email or phone. Thank you for your time.
That was wonderful. Thank you.
Thank you, Julia,
Thank you, ladies.
for that valuable information and all the information regarding trust funding, life insurance, and the charitable benefit riders. Now we're going to jump back into special needs planning. So let me share my screen. Can everyone see that?
Yes.
Yep, looks good.
Perfect. So now to get back to special needs planning, I want to briefly discuss a planning tool that some families may have heard of called ABLE accounts. On May 21st, 2015, the Florida ABLE Act became law. The law is pursuant to the 2014 Achieving a Better Life experience, which allows certain states to establish tax-free savings accounts for certain people with disabilities. The ABLE Act allows eligible individuals with disabilities to save money up to a specified amount without affecting Social Security and Medicaid benefits. In Florida, the ABLE Act was implemented as of July 2016. ABLE United is Florida's ABLE program. They offer a unique program designed to help Floridians with eligible disabilities save for specific qualified expenses and to invest for their future in a tax-advantaged account without losing their federal or state benefits. I've included on this slide the website address for ABLE United. If anyone is interested in jotting that down, you can go to their website. It has great tools, a lot of frequently asked questions, and so forth if you want more in-depth information about the ABLE accounts. I am just going to briefly touch on some of the basics. For an ABLE account, in order to be eligible, the disabled individual must be a Florida resident at the time of application. The disabled individual must either be entitled to SSI or SSDI. They must have a disability that is recognized by Social Security, or they must certify that the individual has a disability that is expected to last for more than 12 months. Finally, the individual with a disability must have that disability and it must have occurred before the individual's 26th birthday. Now, a very common question I typically receive is, are ABLE accounts, have they replaced the need for a special needs trust? Or can you use an ABLE account instead of a special needs trust? So I've created this chart that goes over some of the major differences between an ABLE account and a third-party special needs trust. In my professional and personal opinion, I think that these two tools work best together, a third-party special needs trust and an ABLE account. They both have amazing benefits for our loved ones with disabilities. And having one or the other, while it is great, they work best together as a team. So you will see that ABLE accounts do have contribution limits. You are only allowed to contribute up to $15,000 as of 2020, this year, into the ABLE account, whereas a third-party special needs trust, you can contribute a much larger lump sum. Therefore, a third-party supplemental needs trust is more suitable when you're using a funding tool like life insurance to provide that inheritance to your special needs loved one. ABLE accounts, they do have a maximum size. So the assets in an ABLE account, they are only protected up to $100,000 in order for the disabled individual to retain their eligibility for SSI. Anything above that, they would not be eligible for SSI. Third-party special needs trust, on the other hand, there is no limit. You can fund a third-party special needs trust with as much as you like Julia outlined during her presentation with the Johnsons. They funded their trust with $1 million pay-on-death life insurance policy. That full $1 million would have been protected for the benefit of their autistic son, and their son would have retained his eligibility for all government benefits. An ABLE account can only be funded with cash assets, checks, things of that nature, whereas a special needs trust can be funded with cash assets, securities, life insurance policies, real property, the list goes on and on. Further, under a special needs trust, any kind of investment options you want, the sky's the limit. Those are chosen by the trustee. With ABLE accounts, it's a little bit more restrictive. They do have pre-designed portfolios or certain managers that you can work with as far as investment options. A great point that both the ABLE accounts and the third-party special needs trusts have is neither of them have a Medicaid payback provision. So that is a win-win on both sides here. Lastly, eligible expenses. Under an ABLE account, and more specifically for our disabled loved ones that are receiving Social Security, there is a list of eligible expenses that are allowed for the assets in the ABLE account to be used. Whereas with a third-party special needs trust, the assets in that trust, as I alluded to earlier, can be used for anything as listed under the ABLE account, in addition to recreation, quality of life, entertainment. Literally, the sky is the limit, as long as the expenses are for the benefit of the disabled person and they are used to supplement, not supplant, any of the benefits that the disabled individual is receiving from the government. Now we're going to switch gears a little bit from special needs planning to guardianship. But before we get there, let's talk about the three main tools that we just went over for special needs planning. A first-party special needs trust would be created and funded with the disabled beneficiary's assets, but don't forget, it does have that Medicaid payback provision. So we want to make sure we try to avoid creating this type of trust. A third-party special needs trust is one of the best options for planning for your loved ones who have disabilities. They give you the flexibility during your life to amend, change the trust as necessary, since they can be revocable. Any assets that you want to place in the trust, they're there for the benefit of the disabled individual, and they're protected when it comes to the government evaluating the assets for your loved one's eligibility for benefits. And most importantly, with a third-party trust, there is no Medicaid payback provision. So that trust creator gets to dictate where those trust assets go upon the passing of their loved one with special needs. They get to say that they want the remaining trust assets to go to other family members, other loved ones, charities, different things of the sort. Literally, the sky's the limit. That's why third-party trusts are so great. And lastly, ABLE accounts are a fantastic tool for our loved ones with special needs who want to have that independence and want to have a little control over some assets themselves. They can place assets into an ABLE account, and it can hold up to $100,000 without affecting Social Security benefits. Now let's switch gears to guardianship. Guardianship is a topic that most parents start thinking about when their special needs son or daughter is about to turn 18, which is the legal age for an adult. So at age 18, your son and daughter would obtain their civil rights to manage their own finances, sign contracts, vote, decide where they want to live, decide where they want to work, decide if they want to get married, and so forth. So if we want to try to help our loved ones with disabilities, once they become a legal adult, these are the types of guardianships that Florida provides for. Our first and most common type of guardianship for an individual with disabilities is called a guardian advocacy. Under a guardian advocacy, a circuit court may appoint a guardian advocate without the adjudication of incapacity for a person that has developmental disabilities. Florida statute defines developmental disabilities as a disorder or syndrome that's attributable to an intellectual disability, autism, Down syndrome, and so forth that manifest before the age of 18 and is expected to continue for the beneficiary's lifetime. Under a guardian advocacy, if the disabled individual lacks the decision-making ability to do some, but not all, of the decision-making task necessary for his or her person or property, a guardian advocacy is definitely the way to go. The reason why I underline but not all decision-making ability is because under a guardian advocacy, you cannot delegate all of a disabled individual's civil rights to a guardian advocate, only some of them. A positive point about guardian advocacy is the person that's being considered for appointment, or the person that is appointed as a guardian advocate, is not required to be represented by an attorney unless the guardian advocate is delegated rights regarding property of the disabled individual, other than the right to be the representative payee for government benefits. This is a huge positive for guardian advocacy because families can save on the cost of attorney's fees when most guardian advocacies that I've been involved with and that I see only involve delegating rights regarding the disabled individual's person in addition to their government benefits. Also, under a guardian advocacy, the annual reporting requirements are less restrictive, and the education requirements that you are required to take when you're appointed guardian are also a little less restrictive. So guardian advocacy is typically the first type of guardianship I would always discuss with clients that are looking to have certain civil rights of their son or daughter delegated to them when their son or daughter turns 18. Other types of guardianships in Florida are limited and plenary guardianships. These differ from guardian advocacy, as under both limited and plenary guardianships, an individual is legally determined incapacitated, and some of their civil rights, potentially under a limited guardianship, or all of their civil rights under a plenary guardianship, are removed and delegated to the appointed guardian to exercise on their behalf. The main difference between a guardian advocacy and a limited and plenary guardianship outside of the legal adjudication of incapacity is the requirement of an attorney to represent the guardian. Under a guardian advocacy, like I had mentioned, if it is solely appointed over guardian of the person and just a representative payee of government benefits, an attorney is not required. Under limited and plenary guardianship, attorney representation is required. So that can result in higher legal fees for the ongoing guardianship. The annual reporting requirements under a limited and plenary guardianship can be more daunting. In addition, the education requirements, if you're appointed guardian under a limited and plenary guardian, can be more thorough. Regardless, Florida has many options when it comes to guardianship, and I always discuss all options with all parents that are looking for some type of legal guardianship over their son or daughter when they become 18. On the flip side, if you're looking for a less restrictive alternative to guardianship for our loved ones and family members who may be of legal age but may not need an actual legal guardianship through the circuit court, we have the option of creating advance directive documents. Advance directive documents, like a durable power of attorney and a designation of healthcare surrogate, would allow the disabled individual to appoint someone to help them with financial and medical decisions. This differs from any of the three prior forms of guardianship, as the disabled individual's civil rights to make financial and medical decisions, they are not being delegated or removed and appointed to someone else. All advance directive documents do is authorize someone else, like a parent or grandparent or sibling, to help the disabled individual with those financial and medical decisions if need be. Now that we've discussed the types of tools for special needs planning and how we can best prepare for your loved one's future, let's briefly discuss when you should start your estate plan or review your estate plan if you already have one. If you don't have an estate plan, now is the best time to start one. Like I mentioned earlier in the presentation, especially with third-party special needs trust, which is the best vehicle for planning for a loved one with disability, they are typically revocable during your life. You can amend them, you can change them, and mold them as the years pass to best suit your needs. So it's always best to start it now, to have that estate plan in place, to make sure your loved one is protected and the assets, inheritance that you want to leave them are protected, so your loved one does not become ineligible for government benefits upon receipt of that inheritance. If you already have an estate plan, I typically recommend you review it at least every 2 to 3 years. If your estate plan is already reviewed and up to date, as I previously discussed, then sit down and go through and review your assets. Make sure to make that detailed list of assets, the values, who you want to receive it. Update those pay on death beneficiary designations to make sure that you've listed your third-party special needs trust. If you haven't funded your third-party special needs trust, make sure to speak to someone like Julia, who's a financial advisor who can help you with that trust funding option to provide for your disabled loved one or provide for a charity like the Owls Foundation upon the passing of the loved one. Outside of reviewing your estate plan every 2 to 3 years, if there's any major life changes, if you acquire property, if there's a change in family status, if there's a marriage, divorce, a birth, grandchildren, adoption, whatever it may be, that's always a good time to review your estate plan, to stay on top of it, to make sure that, of course, we are planning for our loved ones and their future. This will conclude today's webinar. I want to thank you for your time, and I want to thank Nicole Poundstone and the fabulous team at Els for Autism for providing me the opportunity to speak today. I truly appreciate it, and I'm immensely thankful for being able to have the opportunity to volunteer and work with the Els for Autism Foundation and be part of all the amazing work that they are doing for our families and our community. I've put my information up here, so if you have any questions about what was discussed today as far as effectively planning to leave inheritance to your loved ones with disabilities and special needs or guardianship, be happy to answer any questions you have. In addition, if you have any questions for Julia, if you happen to miss her slide that had her contact information, you can contact me as well, and I'll make sure to pass on that information to you. So thank you guys so much. I appreciate it.